Good evening, everyone. I'd like to welcome you to the General Government Committee meeting of September 8th, 2021. The time is now 5 p.m., so Cindy, get us started.
Councilmember Dennehy, absent. Councilmember Gonzalez, absent. Councilmember Jaquez,
Present.
Councilmember Reed,
Here.
Councilmember Schmischer,
Here.
Councilmember B. Smith,
Here.
Mayor Pro Tem Hamrick,
Here.
Mayor Smith, absent.
So tonight, we've got on our agenda two agenda items. One, legislation needed for recent tobacco changes, and two, a discussion of a vicious dog ordinance. And so with that, Ryan?
Yeah, the first item before you is the changes to nicotine product regulations. That was actually changed in 2020. It was House Bill 20-1001. And there's at least one change that we need to make within our current ordinances, which is changing the age restriction from 18 to 21. But there's also other changes that at council's discretion you may want to discuss, such as setting up a separate tobacco licensing for under local control or local authority that runs concurrent with the state. And we have City Attorney Ruthie Goff with us today that might be able to expound more on those options.
Ruthie, do you have some words of wisdom for us?
Good evening, council. The biggest thing, as Ryan mentioned, is that you absolutely need to change the age as provided in the ordinance and the memo. The reason for that is it's by federal and state law. So that does need to occur. As far as if you want to license tobacco like alcohol, that's a policy decision that you as a council will have to decide as to whether or not you want to take that on. Other than that, I'm happy to try to answer any questions that you might have, but for sure is the age change that needs to occur.
And we can bring that ordinance back before council at the next city council meeting regarding the age change. The discussion on whether or not you want to set up a licensing authority, that discussion may be better suited for when we bring business licenses back to city council in October for, we'll have the entire meeting for that discussion.
I just have a quick question. Does that affect like cigar bars and like cigarette stores, or are those two things separate?
So it would be, and Ruth, you can correct me if I'm wrong, but it would be anybody who sells tobacco products. They would have separate city licensing as well as their state license.
And would anything be grandfathered, or would they have to, like current operations, would they have to come back through to obtain those licenses?
It would be an annual license. So depending on when you set the effective dates, they would have to obtain that local license at some point.
Other comments by council?
Just while we have Ruthie here, I wonder if you could share with us a little bit of maybe the pros and cons of adopting a separate city license provision.
I mean, the pro is that you're just asking them to have a license like any other establishment, so you're sort of regulating who's going to be able to sell these products within the city. I think the con is that you're taking on an additional administrative task with your city staff. So it might be a good idea to get input from them to see if it's something that they can actually take on. Other than that, it would be very similar to having somebody with an alcohol license, the pros that you have in that instance. So
So in other words, my understanding is by changing that, that's all we're doing is changing the age bracket. It has nothing to do with the sales tax and all that other stuff. We're just going from 18 to 21. Is that correct?
correct.
Okay, thank you.
And of course, my question is, this is fully funded by the state if we decide to set up our own licensing authority?
I don't think so.
I
that
did
be
not
great?
think so.
You gave me pause for a second. I was like, wait a minute. Yeah.
Sorry, it's my version of humor. But, okay, any other comments from council? So that would be my concern, is setting up a new licensing authority would be a further call on city resources. But it's something we can talk about when we do business licenses.
Yep.
Was there anyone in the audience or electronically that wanted to comment on this particular subject? Okay, seeing none, why don't we move on to the proposed vicious dog ordinance?
All right, City Council, you have in your packets both a clean version and a red line version of the existing ordinance on dogs, as well as the proposed changes. We do have our city prosecutor, Tricia McCarthy, who is on Zoom with us as well as Ruthie, and I believe Ruthie was going to provide some overview of the proposed changes.
So I believe you all have a copy or received a red line version and then a clean version of the proposed ordinance. And just to be clear, this is not just a vicious dog ordinance, it's a dog ordinance. So the previous section in Canyon's code, that chapter, I believe it was originally 6.08, was fairly outdated. And almost unusable. And, you know, Tricia and I have talked about this. So basically what Catherine and I and Tricia have all done is gone through it and essentially repealed and replaced the whole thing to allow it to be workable, to allow the prosecutor to have the authority to request certain things or certain conditions imposed when there are violations of the code. Right now, currently, one of the biggest things missing is there was no impoundment authority. So if there was an instance where there was a dog running at large, a vicious dog, cruelty to animals, there was nothing in there that allowed that impoundment authority, which is, in my experience as a prosecutor, and Tricia can talk about her experience as well, is crucial. If you can't take the animal away, there's no way to kind of ensure the safety of both the owners and the people in the general public, and sometimes the animal itself. So I'm happy to go through section by section, or if you guys just have general questions after you reviewed it, we can hit those. But what you'll notice, and I think Catherine also provided a general overview in an email to you all, but the main purpose was to bring it up to date so it could be workable and allow the prosecutor and the animal control officers and Canyon Police the authority to do certain things under the code to address not only vicious dogs, but dogs that could potentially be vicious, so they are exhibiting certain behavior. Wanted to be able to address that, better define what a dog running at large means. There's also, I know that Catherine mentioned this in her email, that the strict liability piece of that to take out the knowledge element of certain violations under this code is important as well. It would be difficult if there was some kind of a knowledge element that had to be proven, then nobody would be able to, everybody would have their dogs running at large, so to speak. I also wanted to note, because I saw it in here, the kennel licensing provisions, they have been taken out of this section, but they are going to be moved. So just wanted to make very clear that that will still be applicable, it just won't be in this section. It's better suited to be in the licensing provisions with the rest of the code. There are some other smaller things that were added that hadn't previously been addressed, like removal of excrement, damage to property destruction of property was sort of addressed in the original code. We've sort of separated things out so there's not sort of this overlap. So when Tricia or prosecutor goes in to try to prove a violation of that section, they're not sort of running into each other. It makes it cleaner to be able to prove those violations. The biggest section, and I think probably where we'll have the most questions, is that impoundment section. because it's been fairly substantially revamped. I am happy to answer questions on that. As far as you will notice too that with the dangerous dog, that there is a sort of a permitting system in place. So if somebody is found guilty of violating that section, the prosecutor can ask the judge to have the individual who has violated that section actually apply for and have their dog permitted, and essentially put everybody on notice that this dog is here in the city. I personally have not implemented that in any of my jurisdictions where I prosecute. I believe Tricia has in some of hers. So I can generally talk about what that means, but as far as like its applicability and its effectiveness, Tricia's probably more equipped to answer those questions. So I'll pass it over to her if we get to that point. Other than that, Councilmember, I'm going to get your last name. Schmizer? No, that's not right, is it? Smisher. My apologies. I do know that you had some specific questions, and I believe Catherine provided some guidance on that, but if we need to go over that for the good of the group, we can certainly go over those as well.
Okay, maybe let's hear from Tricia, if that's all you have, Ruthie?
For now, yeah.
For now, yeah, okay, so Tricia, would you like to weigh in on what we've heard so far?
Yes, good evening, Council. My name is Tricia McCarthy. I am your city prosecutor for the last 3, almost 4 years. This particular draft of animal control ordinances, I think, is really needed in Canyon City. It's been needed probably for a while. This draft gives a mechanism for me to be able to successfully prosecute cases that are of interest to the citizens of Canyon. The biggest changes, and I would echo what Ruthie said, are the idea of potentially dangerous and dangerous dogs. Those definitions and how we define and how we treat those dogs. And then as animal control is out doing their jobs, it gives the animal control department the mechanism in which to impound, and then it gives the court the mechanism in which to hear these cases and determine whether or not a dog should be released from impoundment. Previously, there was no process to either take the dogs and/or there was no guidance given to the court of what happens when we do take a dog. This cleans that up. The potentially dangerous and the dangerous dogs are standards that I use in, I believe, about 8 of our cities in the Denver metro area. In addition, the state of Colorado has adopted this standard and gone away from what I would consider a historic position, which is the vicious dog standard. It mimics the vicious dog standard, but it breaks it out into 2 very different categories, which gives myself the ability to kind of move within those categories, because not all vicious dogs, not all dangerous dogs, not all potentially dangerous dogs are the same. As council can see, the definitions are quite different, and it recognizes the differences that we may have in dogs in our communities. This tool, I think, will be really beneficial for myself, for Judge Allen, and obviously to the community as we continue to deal with our growing population and the population of dogs in our community that need to be handled in a different manner.
Okay. Yes, Ryan?
I just want to say that Chief Schick and the police department did work very closely with the attorneys, and they are in favor of these changes and support this modification.
Thank you. Council, I would suggest that we hear from the audience right now, and we can circle back to ourselves. And so I've got some requests to speak here, and I just, as they were piled up, I've got Bo Cruz. Would you like to come speak to us, please?
Well, I apologize, I didn't hear everything. And I was really concerned about changing the language in that ordinance for vicious dogs, because as it first reads, it said running at large. And this dog jumped my fence and got in my yard and killed my little puppy. And it has gotten out many times and just held the whole neighborhood hostage because everybody runs. And I wanted it where and we had witnesses, that if something like that happened, that they could come and get that dog and impound it and then have a hearing and then judge whether it should be euthanized or whatever. And in this case, I wanted it euthanized because this dog was rotten. It caused a lot of trouble in our neighborhood. And I guess it happened today, finally. And this was June 15th when it attacked our little dog, and it took this long to get it done. And I stayed on it till I understood what was going to be done. So the next person doesn't have to go through what we did as far as, you know, waiting and seeing and what's going to happen to the dog that did the damage. And it was very sad. So I appreciate your time, and I appreciate the effort that you're all doing to do this. And thank you, Tricia, too, for all what you've done. I've talked to her a couple of times on this. And I don't have anything that you guys have, but Doug does, and maybe I can get a copy from him. So I understand what you're saying and doing as far as changing the language in this ordinance, because it definitely has to be changed. Thank you.
Thank you for that, Bo. And I'd like to just tell you that, you know, I myself am personally very sorry and sad that as an owner of pets myself, that you had to go through this experience to be able to bring it to our attention, that there was something that really wrong with our ordinances that needed to be corrected. But really, hopefully you'll find some solace in the fact that we did hear you, and we are taking some action here to try and make it better.
And I do appreciate that, all of you.
Amy.
Thanks so much for sharing that, Bo. And maybe just to turn your statement into a bit of a question for Ruthie and Tricia, with this new ordinance, would that address and resolve Ms. Cruz's concerns?
I can step in unless Ruthie wants to talk.
No, go ahead, Tricia.
This ordinance would have resolved this entire situation from the moment that the dog killed Miss Cruz's dog. Obviously, it would not potentially resolve or prevent that from happening because this dog was not on our radar prior to that incident. The moment it happened, had we had this ordinance in effect, animal control officers would have lawfully impounded the dog, and that owner would have been subject to the impound rules and regulations, which would have given her a hearing in front of Judge Allen at the next court date, which we have court about every 2 weeks. So depending on when it happened, she probably would have had court and been able to be heard by Judge Allen in about 10 days. In this particular situation, I, as the prosecutor, would have been asking for surrender based upon, obviously, the factual situation, the requests of Ms. Cruz, in addition to the requests of the neighbors, who all echo Ms. Cruz's statements that this dog was holding the neighborhood hostage. And then it would have been up to Judge Allen. Judge Allen would have reviewed all of the testimony and all of the evidence that I would have presented. And the standard that is presented in the code is that Judge Allen would have had to have made a determination as to whether the dog could be safely released back into the community. So this would have cured from the moment of the incident. It would have resulted in a favorable disposition, hopefully for Ms. Cruz. Based upon my experience as a prosecutor, I think Judge Allen, after listening to all the facts and evidence, would have probably ordered this dog surrendered.
So I have kind of a follow-up to that, Tricia. So if, and this is speculation, but if this incident had not occurred, but the neighbors were bringing this dog to the attention of animal control officers, it potentially could have prevented this outcome that we now know about. Is that true?
It's true. Under the new ordinance, some of what this dog has exhibited would classify under potentially dangerous. So we would have had the dog running at large, which that has been described on numerous times. From what I've been able to hear from the neighbors, the dog has exhibited an attitude of apparent attack, very aggressive in the neighborhood. And so if we had had the potentially dangerous, the animal control officers would have had the ability to bring that dog in under the potentially dangerous, and it would have put the dog on our radar. It would have triggered the licensing requirements, so we know where that dog is. The owner would have some affirmative obligations to take with the dog. It may not have prevented it, but it would have at least put this dog on our radar.
Thank you. Any other questions or comments from council right now? We do have a couple more audience members. Frank, did you want to?
Well, let's go to the audience
Okay,
first.
so thank you, Bo, for that. And Susan, would you like to come up, please? Although, is this a twofer here that we've got? Thank you. Please go ahead.
Green light.
Okay, thanks. The dog y'all are talking about was put down tonight at 4 o'clock. It came to the shelter, or it actually never came to the shelter.
Correct.
When we were informed that it was gonna come to the shelter, we knew that it didn't make any sense for it to come to the shelter because we were gonna put it down, so we sent it straight to the vet, who put it down around 4 o'clock today.
Correct.
Is that accurate?
Correct.
I guess a couple of things I'd like, well, should she be talking first since she?
However you'd like to do it. We're pretty informal in these meetings.
I know when I was up here and I last addressed you folks, I said that I would be happy to help you redo this code, with whatever help that was. And Ryan sent this to me yesterday morning, I believe it was. And I opened it last night before I left, and it was pretty substantial, so I knew I wasn't going to have any time to deal with it last night, and I thought I was going to have time to read through it today, and unfortunately my day got away from me. So I've only had time to skim through this, but the few things that I have skimmed through, there are some things in here that I think Susan and I can bring to the table and tighten up this code even more. I mean, Tricia, what she does is, she's got a lot more experience in this than I do. I've been doing this for 18 years, and Susan's been doing it for 17 years. So Tricia can speak to the legalities here. I understand that, but I think we can speak more to the day-to-day operations of what we're seeing in this I guess it's called the draft ordinance, that we'd like to have a say in helping tighten up for the city.
Great. So I would suggest that you listen as the discussion progresses this evening, and perhaps get with Ryan, written comments, if you have written comments that you can make about specific sections, and then be prepared to come back, if you can, when council formally considers this rule for enactment. And if changes haven't been made that you feel are appropriate or necessary, you can certainly talk to us at that time. But work through Ryan You know, and I'm sure that we always welcome comments and written comments.
Very
And
good.
so,
Yeah, there's a few things in here, John, that they're not accurate. You know, like, one of them, if I think it was, if an animal bites, in this new code says that the animal needs to be held. I don't know if it specifies the dates, but there's no state statute for that. You know, so I just found,
If an animal bites another dog, so if a domesticated dog bites
exactly,
another
another dog, not a
then
human.
it's to be held at the shelter for rabies quarantine. And I did bring the rules for Colorado for the rabies and quarantine. And if it's a domesticated dog and another domesticated dog, there is no quarantine for that dog. If a dog ruffles around with a skunk or something and you can't catch that wildlife, then yes, that dog needs to be quarantined for a minimum of 30 days because you can't locate what he got in a fight with. But a dog on dog, my dog, his dog gets in a fight, there is no quarantine for that. It's only quarantine for people. And I can leave those with you guys if you'd like those.
thank you for
Yeah,
that.
so tomorrow, when we come in tomorrow, we'll sit down and we'll put all this on a Word document and send it to you, the things that we read through.
And I can send it to you in Word format if you want to make comments on it through Word.
Excellent, excellent, yeah, thank you, thank you.
I did have a couple of concerns on the dangerous dog and the way that it's worded, and I'll use the example from today with Coco. It states that Coco was to be surrendered to the shelter, and the shelter can do with what it pleases, but not in the city of Canyon City. I'm not sure if you guys are familiar, but we are regulated by PACFA. So there are certain rules and regulations to keep our doors open that we have to go by, and one of them is having a dangerous dog. So to have the court say, you as an owner, surrender this dog to the shelter, they can do whatever they want. If I happen to have my PACFA inspector stop in, and she does whenever she wants to, and she sees that I have a dangerous dog and it's on paper, we are in violation. So I don't feel like that should be on any shelter. If the court has said this dog needs to be euthanized, it really should fall on the responsibility of the owner who had that dog. It shouldn't just be put in a shelter to jeopardize our staff and put them at harm's way when we know this is a vicious dog. We still have to transport that animal to the vet. We have to catch pull it. We have to do all these things. Our vet has to do it. It just seems like if it's going to be in writing, it should make the irresponsible owners accountable. And I don't think dropping off a dog and driving away makes them very accountable.
Well, there's two different issues there. One is your ability to receive the dog, and the other is the owner's responsibility. But I hear what you're saying about your ability to receive something that has been adjudicated as a dangerous dog. And so we probably have to do a little bit of thinking there to see what's possible or what mechanisms we have to perhaps handle that situation. For instance, the particular dog that we're talking about was taken directly from to a veterinarian tonight. So
Correct.
this afternoon, and so maybe that.
I would like to add on that.
Mhm.
The dog was taken to the vet because we wouldn't let it come to the shelter.
Yeah.
So we asked the animal control officer and the sheriff.
Because we couldn't handle it.
We
Yeah.
can't handle it. If
Understand.
they could pick up the dog, we would arrange the vet to euthanize. And the previous owner had said she had no money. It wasn't about money. It was about safety.
Mhm.
And the safety for my team, who's not
Sure.
qualified to catch, pull, and transport, because we do not euthanize at the shelter, a vicious dog. So we talked to Tricia, we talked to animal control, and came to the conclusion that this was going to be what was in the best interest for everybody.
Gotcha.
And I think the owner went with the animal control officer.
We
Yeah.
requested that the owner go,
Mhm.
that animal control officer follow the owner to
Sure.
the vet.
So that sounds like there's some adjustment that needs to be done there to cover the the inability of the shelter to receive something that's been adjudicated as a dangerous dog.
And I do agree with you. I think that the owners should bear some responsibility to this, because ultimately, that's what we take on as pet owners, is that responsibility. And I definitely agreed with you, and I was gonna make a comment later on. I wanted to hear from you guys first, that I do agree with that. I think that the ultimate responsibility is not the dog, it's the owner, and I agree.
Okay, yeah, Ryan, yes.
So just out of curiosity, if this had been handled under the new ordinance, the animal control officer would have taken possession of that animal. They would have had to take it to the shelter until it could be heard by the courts. How would that situation have been handled with these same concerns?
Go ahead.
The first time Coco came to us, that was a situation, and we were to hold it until court date. It had been 3 days. We could not touch that dog. We had to put him in a double kennel to clean and feed him. We had to open the guillotine, shoo her onto the other side, close the guillotine, go in and clean it, and do the same thing every day. But for 3 days, we could not touch that dog. And if you went at her with the catch pole, she came at us just as strong.
So what I'm hearing from you folks, you're saying that you're kind of telling us you can't take a vicious dog until, so what good are you in a sense
No.
as
That's
an
not what
animal
I'm-
shelter that we support?
That's not what I'm saying, sir. I'm saying that when you have a disposition of a dog that's been made, and it was made, it should not be my responsibility to put my team in harm's way. The owner should take the responsibility and take the dog down and have it euthanized.
I know that, but if the court says you have to keep the dog, it's a vicious dog, what I
And
heard
we
you
will,
say
and
is
we
you
would
won't be
keep
able
it.
to do that.
No. Susan just explained to you that we would keep it, and she explained how we keep it. We have double kennels where we can put a vicious dog in and shoot it to one side and clean one side, and shoot it to the other side and clean that side. So we would take the dog. We're not
Okay.
saying we're not gonna take the dog.
All right, well, now you're saying you would, that's all I want to hear you say is you're
Okay.
going to take the dog if the court deems that it has to be sent to
Absolutely,
you.
absolutely,
All right?
would absolutely
And then-
take the dog.
And then it's up to the court to decide whether or not the dog has to be euthanized down the roadway. I understand it'll put you into some inconvenience, okay? But the purpose for our shelter here is to receive animals based on what the law has in place at the time. Okay, it wasn't there before, but it's going to be there now.
I agree with you, sir. However, this was not a holding the dog for a court hold. This was surrender the dog to me. This is different than I have to hold it for 30 days until we go to court.
And what Susan was speaking to before is, let's say Mandy has a vicious dog, and that dog comes to the animal shelter. We can't get near that dog, but let's say that the judge rules that that dog should be euthanized. We still can't get near the dog, but there's a good chance that Mandy can come in and she can actually leash her dog up and take her dog out and get the dog to the vet safely. That's what we're talking about.
So
Just
it sounds-
interject.
Go ahead, Tricia.
I think we're getting bogged down in what happened with Coco today. I would just like to point out that Coco is a very unusual situation because of the code in which we have in existence at this moment in time. And I don't want to get too much into the details as to how this happened, but essentially Coco was released because we did not have the authority to impound Coco to begin with. I gave the owner the opportunity to cure this particular issue, and she did not address the approximate 15 conditions I put on the release of Coco. In addition, there were several additional violations where the dogs were out running in the neighborhood. So we brought Coco back to court on a motion to revoke the plea bargain. This is an extremely unusual situation, which if this code was implemented, we're not going to have this exact situation. But what we are going to have, and what certain councilmen have pointed out, we are going to have a situation where Coco is lawfully impounded, and we're going to need the shelter to be able to take that dog until adjudication. Adjudication could be the hearing from the municipal court as to whether the dog can be safely released. So at that moment in time, if Judge Allen makes a decision that the dog cannot be safely released, we would be asking the shelter to dispose of that dog however Judge Allen sees fit. The ordinance does allow for the pet owner to post a bond between the hearing and the trial. So there could be some situations where that pet owner does in fact post the bond, and then through the course of the case moving through municipal court, the dog is finally adjudicated as a dangerous animal. That is a situation where the dog should still be in the shelter. And I think that's more of a policy and maybe an intergovernmental agreement that needs to happen between Canyon City and the shelter.
Well, no one's ever said that if a judge says we need to hold a dog, we're not going to hold it. No one said that here tonight. I haven't said it, Susan hasn't said it. If a judge comes down and says we need to hold the dog tomorrow, we'll hold the dog if it's 10, 30, 40, 50 days. We'll hold the dog as long as possible. No one's ever said we would not do that. All we're saying is if we have a dog that is deemed vicious by the courts and we have the dogs at the shelter and we can't handle the dog, we would just like the owner to come in and to take that dog to the vet if possible. If not, then we can put the dog down. It's going to be incredibly stressful for that dog to do that, incredibly stressful, versus an owner coming in and taking the dog.
I can tell you that I do not believe I would ever agree, or Judge Allen would ever agree to, once the dog has either been found at a hearing that the dog cannot be safely released into the community, or if the dog is adjudicated under this new ordinance, I don't believe the court will be in the position to allow a defendant to remove the dog from the shelter in order to take it to a veterinarian. I think this situation was very different because the defendant actually had possession of the dog. When we change the system to what we're proposing, if Judge Allen makes those determinations, it would be the city's position and Judge Allen's position that the dog does not get returned to the owner for the purposes of destruction.
Well, in the 8 years I've been here, and Susan can fill in this answer, I don't know if a judge has asked us to put a single dog down. So as you said, this is a very unique case. So in the 8 years I've been here, we've never, ever had an order from the judge come down to do this. So we're talking about, I guess, Coco here.
So I have a
Yes.
question. And I may be incorrect, but I think where I needed some clarification and maybe where there was some miscommunication is when you had mentioned that the way the shelter is, was it PACFA?
PACFA, yes.
Yes, and that you would be in violation if you had a dog that was adjudicated as dangerous in the shelter. So that is what I interpreted as well. And so I just was trying to get clarification because you said that that would be possible. So would you mind just explaining that piece a little bit? Because I think there's some miscommunication. I know I'm confused.
Sorry about that.
No problem, thank you.
PACFA regulates us. If we have a dog that the court has deemed a dangerous dog, we cannot transfer it out, we cannot adopt it out, and we cannot warehouse it. So the only option we have is euthanasia. That is it.
What does warehousing mean? Can you explain that?
Warehouse means that you have a dog, you know it's never going to leave your shelter. It's just staying there. There's no, can't go outside. It's just existing.
So when we were talking about the days, the 30 days or, you know, those different amounts of time, is that different than warehousing because there's a definitive time on that, or is that
They
the
are
same?
on a court hold.
Okay, so it's
when-
different.
Yes, so when PACFA comes in and they have to be in a separate place in the shelter, no public can come in contact with them at all. So they have to be behind a fenced gate, and there has to be a sign on their kennel that says dangerous dog. And if PACFA was to walk in, they would want to know, why is it a dangerous dog? It's on a court hold. They probably would say, could you follow up in 30 days? Let us know what the disposition is.
Okay, thank you for explaining
I
the difference
didn't
because
say-
it completely
I just kind of
confused
blurted
me.
it out. I
No,
do
that's
that.
okay. I appreciate the explanation. Thank you.
So it's, if I understand, how this proposed ordinance would work, there may be cases where a dog jumps from the dog category to dangerous dog category. But most of the time, through the operation of this ordinance, it'll become a potentially dangerous dog first, which you are allowed to
Yes.
to handle and have, I mean, considering safety concerns. But so I think that, and then at one point, the judge may rule that the dog is now a dangerous dog and requires euthanasia, and at that point, your procedures still allow that to happen.
Correct.
Yes.
So if we have the dog for 30 days on a court hold, and say the judge comes back and says, we're deeming this dog to be euthanized, the dog has been there 30 days, we will sedate the dog, and then we would transport it to the vet. So the dog will still be there, we will do the sedating, which is trazodone, and then we transport it to the vet.
Gotcha. Any other questions or comments at this point? Yes, Bo, hate to have to ask you to do this, but can you please come to the microphones?
I'm sorry to take up your time, but I just wanted to understand it, that when this happened, they took the dog to the kennel. It stayed there 7 days because we found out that it was illegal for them to take the dog because it was in the house. And it was written up as a vicious dog because it did kill my puppy. It jumped our fence. And they sent it home with the owner after 7 days. The judge ruled it could go back to her. And that's what frustrated me because I didn't understand why she got her dog back. And then we had another hearing and I didn't get to go because they changed the date on it and didn't tell me. And she had to be spayed. She had to have 12 hours of what they call obedience, and they had to have an enclosure for it. And she didn't do any of that stuff.
Yes, ma'am.
And she got her dog back.
I
Sure.
think that's what we're trying to do with this ordinance is to prevent that from happening
Right.
again by giving the prosecutor the tools that she needs in order to, to streamline the process and so that it's legal for them to take the dog,
Right.
if that makes sense.
Right. I
Because the way the
understand that
ordinance
now.
was written, their hands were tied
Yeah,
legality-wise,
exactly.
so.
And that's what frustrated me, that dog was returned after 7 days. And
Sure.
I understand now, but
The
it
fir-
was frustrating in the beginning.
The first time Coco was at the shelter, he was there for 3 days. And then the judge came in and said to release the dog back to the owner. And that's when I was shortly after that, I was giving you all a shelter update. And then this happened and I addressed it. And I said I wasn't happy that we were told to give that dog back to the owner. And then everything happened since
Sure.
then.
Okay. So Amy, do I understand then that you're going to make some written comments, some written suggestions on the ordinance, is that right?
I did make some written comments and also had some questions that I provided to the attorneys in advance of the meeting. I'm happy to share briefly what some of those were, if that would be helpful.
Sure, that might be nice. I may have some of the same concerns. I do have some specific comments I'd like to make on the ordinance. Does anyone, before I get started, does anyone else have something they'd like to say up here on the stand? So the potentially dangerous dog, the first of 6 potential behaviors that can place a dog in that category includes acts in a highly aggressive manner within a fenced yard or enclosure and appears to a reasonable person to be able to jump over or escape from such fenced yard or enclosure. And what my concern here is our first charge is public safety. But that's also tempered by our ability, to be free citizens in this society. I know of a situation in Canyon City where there's about a 3-foot fence, and there's 2 dogs, and they're medium-sized dogs, I'd say, my first comment is, number one, with the appropriate dog, even a 6-foot fence can be jumped over by a dog. And so I have some concerns there, and the particular situation I'm talking about is actually on a route to school, and the dogs love barking at kids as they walk by, and so they run up and down and bark at the kids, and they have a 3-foot fence that they obviously could jump over. And so what would be the difference between perhaps an aggressive manner and highly aggressive manner in that case? What would the dogs have to do to be put in the highly aggressive manner?
So typically, with a highly aggressive manner, we're talking about things like charging the fence, growling, baring teeth, those sorts of behaviors. That's typically what I have seen in other jurisdictions. We can certainly clean that up and provide a definition of what highly aggressive manner means to give examples. But those are typically what I see. General barking, probably not going to rise to the level. My dogs go crazy at the window when people walk by. But that's not the kind of behavior that we would consider aggressive. Now, if a dog is charging, throwing its body against the fence, if it's at the end of a lead and it's essentially choking itself because it's trying to get at the end of it, those are the kinds of things that would be considered highly aggressive, I think. I don't know if Tricia has seen other behaviors, but that's been in my experience. So certainly, if that's something that the council would like better defined, we can certainly do that.
And I certainly understand the difference between a barking dog and a dog that is baring its teeth, snarling, and appearing ready to bite. There's a big difference there. We have 2 little dogs. We call them our doorbells. They do the same thing when people approach. My second question
Hold
is.
on, if I could just
Sure,
jump in for a
please.
second. So in that section, what I focus the most on is acts in a highly aggressive manner. The fact that the dog can jump the fence, as you have correctly pointed out, a lot of dogs can jump even a 6-foot fence. Where I would say it is different, we look at dogs and whether the behavior is appropriate for that dog, that breed. This particular ordinance carries with it some discretion for animal control to charge a potentially dangerous, as well as it gives myself discretion and the court discretion when we're looking at this. I'm going to be looking at cases where the dog is in fact not just running up and down and barking. That's what dogs do. Dogs protect their home. What we're looking at is situations where the dog is growling, barking, the dander is up, and then I like to see situations where the dog is in fact lunging, throwing itself against the fence, attempting to get over the fence, and situations where it's pretty clear to the witnesses that this dog is attempting to bite you and attack you. It's more of an attack type situation. Had it not been for the fence, the dog would have attacked. Some of PDA, it is going to fall to me to make sure that we are appropriately charging and appropriately prosecuting these cases. In addition to me, we also have obviously Judge Allen, who is another gatekeeper to make sure that we're not just prosecuting someone or a dog for running up and down against the fence. That's not going to happen.
Great. Thank you for that, Tricia. So that does bring up the question then, once this ordinance is passed, in whatever form, what type of training or do we expect our animal control officers to undergo to be able to understand some of the differences that you just pointed out, for instance, Tricia?
Yeah, the PD will go through and they have a training manual that they have, and they'll have to update it to include the information that we've put in here and those additional definitions and exhibited behaviors that we're looking for, what Tricia's looking for.
And that to me is the important part, is feedback from Tricia when they do that, so that everybody's on the same page. That'd be really
Absolutely.
great. So I had a similar comment on the next one, the without provocation, where it talks about a person is on foot or in a vehicle or a device which allows such person to be in motion, but menacing, terrorizing, that apparent attitude of attack, I think that takes care of my concerns there. Then under the definition of serious bodily injury, it talks about burns. I'm not sure we've got dogs with blowtorches running around. And then on that same page, under 5, powers and duties of animal control officers, under C, it shall be lawful for any animal control officer. I believe those are ors. Is that correct, between those 1, 2, 3, or 4? Is that what those are intended to be?
I apologize, can you,
So I'm on page 5,
yes,
6.08.030, powers and duties, C, and then the numbers, 1, 2, 3, 4. Is there supposed to be, is those intended to be ors?
correct, yeah. If any of those exist, then it shall be lawful for the animal control officer to enter upon private property.
Okay, they're probably just, that's probably just a structural thing that needs a little bit of
Yes,
a
the
tweaking
intention
there.
was if any of the following conditions are met, so yes, if
Yes.
one or more of those are met, then
Gotcha.
they have the
Understand.
authority.
Then on the next page, C6, in that same section, E, it says notwithstanding paragraph C2 and C6, we don't have a C6.
Correct, and that was actually one thing that Amy had pointed out as well, so I believe that was a drafting change from one draft of ours to
Great.
the next.
Great minds think alike here, I think, you know. And my other comment, then, I have one final comment, and that's on the, under the definition where we talk about control. And it says that control should mean that the dog, and that's not a dangerous dog or potentially dangerous dog, that's any dog, is on a leash quarter chain not more than 10 feet long. And the concern I have there is that I did measure all of our leashes for our 9-pound, 12-pound doggies, and they're all 16 feet. And so I would suggest that we don't put a length limitation, but leave it as that, that the person has a physical ability to restrain the dog. Because we did, later on, when we talk about a dangerous dog, we do require that they are on a 10-foot leash, which sounds entirely appropriate. But for just, you know, I've walked my dogs, and I see people that let their dogs run out at the end of their leash very far, in an area where it's safe to do so, obviously. And so it seems to me that that's probably a little bit of overkill there. Any other questions or comments from council, or?
I did have one change. When it talks about licensing, it references the city clerk. It's actually the police department that does the licensing, so that will be another adjustment that is made in the final document.
Thank you for that. Amy, did you have a comment?
Sure, I'm happy to go through my comments and questions as well. I did have just typographical and those sorts of edits throughout, which I won't go through. I did provide them in a track changes version. But just in general provisions A under purpose, I think it's important that it's not dog owners are encouraged to respect the rights of their fellow citizens. They really must respect the rights of their fellow citizens. And then just in terms of a few of my questions and comments, had a couple of the same ones as John, but then also I really wanted to hear from Chief Schick about the 608030 powers and duties of animal control officers, paragraph E, which is about the animal control officer having reasonable cause and to immediately enter people's personal property. I just wanted to really understand how they were going to train, what sort of thresholds they were imagining there, really ensure that we had a good appreciation and understanding of when that would actually be used. And let's see. In terms of the noisy dog, which is 608090, I noticed that we had specific hours between the hours of 10:30 p.m. and 7:30 a.m., and that made me wonder a little bit more about our city noise control ordinances. And I understand that we don't really have specific times, and that made me recall that during our Picture 2040, we had quite a few citizens ask if there was something that we could be doing more about noise control and noise ordinances. So just wanted to flag that that may be something that's worth kind of a longer discussion about, not necessarily specific to the dog ordinance, but did want to make sure that we had harmony between the hours that we're listing here and any other hours that we may want to consider for noise ordinances. Let's see. Had a couple of questions about the kennel and the shelter, and was so happy that Doug and Susan were here and that you'll be part of the process of really tightening this up and ensuring that it has and reflects your expertise and your input, as well as that of our city attorneys. I did notice on D5, oh, whoops, I need to give you the site, 608120, potentially dangerous dogs. D5 is that the dog's microchip information, if applicable, but then later we require that potentially dangerous dogs be microchipped. So just want to make sure that we're internally consistent. Sorry, I'm going really fast, but I have provided all of these in writing. Still in the potentially dangerous dog, number 8. We start talking a lot about proper enclosures, and I think that that might be another area that we want to define. What does proper enclosure actually mean, and then how can we actually give Tricia the tools to hold people to what proper enclosure is? I think I had a couple more. So just in terms of the violation and penalty, which is 608210, so B under this section is about a fee if somebody doesn't license their dog. And I understand that the current licensing fee for 2 years is $22.50, and the fine is $25 for not doing it. So I just want to make sure we aren't creating a perverse incentive for people to not license their dog and just pay the fine. So just wanted to flag that we may want to think through that structure and how much it is. And then I also just noticed that C, under the same violation and penalty, this one's about the noisy dog ordinance, and I think this is the only one that doesn't escalate. So if you call in about a noisy dog, one time it's $45, and if the problem isn't cured within a reasonable period of time, there isn't an escalation in the penalty. So we may just want to consider whether from a policy perspective we want to have the same kind of escalation there as we do with the others. And that was it from me.
Thank you. Those
I can
are,
jump in on the powers, subsection E, if you would like.
Sure, that would be great. Thank you, Tricia.
And obviously Chief Schick could jump in on it. Subsection E is an extremely rare situation. I would call it a more of an exigent circumstances situation. This is going to be a circumstance in which the dog is in such danger of dying. We are going to need some pretty specific facts and evidence for the animal control officers to act on this. I will tell you, this is an extremely rare situation. More often than not, we're going to ask the animal control officers to go quickly get the warrant. But this could potentially be used, for example, if we have a dog in a hot car and the dog, at the determination of the animal control officer, is in fact dying. We've seen a couple of these in Canyon where it's pretty desperate and we'll break the glass and enter the car. I have seen other situations where we had a dog on a property in Canyon that was tethered to a dog house. We could see the dog from a public view, and it was quite obvious that the dog was dying of starvation. so animal control entered and retrieved that dog. When you look at all the dog cases, this is probably way less than 1%. It's extremely rare. How Chief Schick has been dealing with it, obviously we have police officer sergeants that supervise animal control, and any of these decisions are going to need to go through the sergeant supervisor, and they're going to be the ones that will help and assist to make that decision, and or they always have my cell phone number to call me if they need to get a quick answer as to whether this is legal. But generally, the first thing we do is get consent. The second is search warrant, and E would only come into play in those extremely urgent, life-threatening situations.
Thank you for those clarifications. I think it may be worth taking another look at how E is phrased then, to make that a little bit more clear in terms of what the roles and responsibilities of the animal control officer is, just so that we aren't requiring them to make those sorts of judgment calls, particularly understand the hot car analogy, definitely, but it also just mentions property, which could be someone's home, which is, then it's a lot less clear that it's, you have visual line of sight, that you have a dog that is in danger of dying. So I just think we may want to take another look at that and make sure that it's really tight.
Thank you. I appreciate those comments. They'll certainly echo a lot of my concerns, and I'm glad that you've brought those forward. Do we have any other comments or discussion that we need to have? Yes.
So I guess my comment would be is to Doug, if you could get those comments to us, to Ryan, so that way we do have the opportunity from that perspective as well. I feel like this ordinance is taking care of the important legal needs. I just want to make sure that our definitions, I mean, we just met with you not that long ago as you went before the state to clear up some of their definitions, and so we definitely value your opinion and your input on this. And so if you could just get that stuff to Ryan, I would like to be able to see this a little bit ahead of, by the time we actually present it to a council meeting, to be able to go. So that way, if we do need to continue to have more conversation, we have an opportunity to. I don't know what, I know obviously it's important, we have a deadline, but I just, I don't feel like we've had adequate time to be able to have conversations about definitions and how we're gonna handle it. I don't like that we had wording in here that went against what the shelter was able to do. That's concerning to me. I feel like that could have probably been discussed prior even to this. Because we do have a contract with the Humane Society here in Canyon City about what they will do and what they won't do and what we're giving them funds to be able to do. And I just want to make sure that's really clear going forward, that we're not expecting them to do something that they're not equipped to do, because I don't think it's not a matter of inconvenience for them to be able to transport. It's danger to human life of people who we are also charged to protect. And so I just want to make sure that all of that stuff is just very clear, very tight, that we are working on this partnership, because we don't have another shelter or another place to be able to take care of this. And I don't mean like I'm trying to get another shelter. That's not what I'm saying. I want us to be able to work closely together like we have been able to in the past. And so if there's something in here that isn't collaborative, I just want to be able to know about it and to address it instead of having to bring it to council and vote on it and just kind of go down that path when we come up to contracts again later, so.
I'll meet with Susan tomorrow morning, and we'll shoot everything over to Ryan sometime tomorrow.
Thank you, appreciate it.
And in the spirit of those comments, Mandy, what I recommend, Ryan, if you can, please make sure that if the shelter has concerns, that when they give you comments, if those concerns aren't alleviated or addressed, that there's some conversation that goes on so that everybody can get on the same page. I would hate to see you submit comments that we resolve internally, but you're not aware of that resolution, or perhaps legalities involved or whatever. But we would like to continue to look at you as a partner, and with that, that means dialogue. Yes, Amy.
Thank you, Mayor Pro Tem. Wholeheartedly concur as well. And I'm sorry, I just had one more. I think that there's a requirement in 608120, the potentially dangerous dogs, that individuals have signs that comply with standards established by the city administrator. And my understanding is that we don't currently have those standards established. So I just want to make sure that we establish that at the same time as the ordinance, so we aren't requiring people to comply with something that we don't currently have. But also wholeheartedly concur with what John and Mandy said about our partnership with the Humane Society. Thanks.
Is the way that you could address that, Ryan, is by having a table attached or something? I mean, when we were going through the zoning regulations, there were times we put things down in an appendix so that we didn't codify it, but dealt with it, had the ability to change it as
Yeah,
needed.
there's an administrative process for that.
Yeah, okay. That answer your question? Good. Yes, Frank?
I guess my only question is, because we got an ordinance in front of us, are we gonna do anything with the ordinance, or we just let it go back for revisions? Or do we go ahead with the ordinance on first reading, allow the revisions to be made, so we don't keep going back and forth from day to day and month to month to get this thing finally resolved?
So this is a committee meeting, so you can't take any action tonight. From council's perspective, we're going to need some time, or more so the attorneys might need some time to make some adjustments and obviously incorporate Doug's feedback. My goal, if council's okay with that, it would be to bring this ordinance back to for first reading at the first meeting in October.
Okay, so it will come in October for first reading? Then?
Yes, sir.
Okay.
If that's fine with council.
Well, absolutely. In a case like this where we're actually dealing with public safety
Yep.
issues, considering what Frank said about, we don't want to keep spinning the wheel here, but sooner is better if we can make it happen.
Yeah, if we can make it happen sooner, we will, but depends on the extent of comments that we receive.
Okay, if there's no further comments, then we're adjourned.